Congress recognized that leaving environmental enforcement entirely in the hands of administrative agencies was not a good idea, so Congress empowered citizens to file lawsuits enforcing the laws. Today, almost every federal environmental law has a citizen suit provision. Citizen suit provisions generally allow three types of lawsuits. The first are citizen enforcement actions. This allows citizens to act as private attorney generals to supplement government enforcement against those who violate environmental regulations. However, if a federal or state authority is diligently prosecuting an action to require compliance, then the citizen suit is not allowed. The second type of lawsuit is a deadline suit. This allows citizens to file lawsuits to force government officials to perform their mandatory duties. It doesn't apply if the duty is discretionary. These suits challenge an agency's failure to meet a statutory deadline to take some action. This allows citizens to force a recalcitrant government agency into doing its job. The third type of lawsuit is one where citizens can file lawsuits to review the legality of an agency action. These provisions supplement the judicial review provisions authorized under the APA. This is the case where a citizen challenges the merits of the agency's action. Most of the cases in this course involve this type of action. One important development is that some environmental laws require that citizens have the right to sue only if the violation is continuing on in the present and not a wholly past act. This is based on the phrase that the alleged violator had to be in violation, which implied a present or future potential violation. Congress began amending certain laws to add the phrase alleged to have violated. A determination as to whether the alleged illegal conduct is ongoing is to be made as of the time the complaint is filed, and citizens only need to make a good faith allegation of an ongoing violation to be able to file suit. Ongoing violations can be established either by showing that violations continued on or after the filing of the complaint, or by producing evidence of a continuing likelihood that intermittent violations would occur. Another important consideration is that of a 60-day notice to the alleged violator that the citizen intends to commence a citizen suit. As mentioned above, if the state or EPA does commence its own action within the 60-day period, then the citizen suit is barred. This is because the government action has rendered it unnecessary. When alleged violators correct an action prior to the expiration of 60 days, this raises the issue of whether or not a company can escape liability by completing remedial action after the complaint is filed, but before judgment is rendered. One view is that citizen suits can simply stop continuing violations based on fear of a lawsuit, which renders the lawsuit moot once the violation ceases. Do you think this is a good use of citizen suits? Do you see how this might be abused by filing frivolous lawsuits? In this famous case from 1990, the 11th Circuit found that claims for civil penalties were not mooted by post-complaint compliance. But do you think post-complaint compliance would make the citizen lack standing, as you learned in our first module? The courts have said no, because civil penalties can benefit plaintiffs by deterring future violations.